The Democrats on the Judiciary Committee are up in arms, and they're demanding that Merrick Garland, in the last remaining 4 or 5 days, dismiss the criminal case in Mar-a-Lago against the 2 remaining co-conspirators in order for Merrick Garland to release to the American public the Mar-a-Lago report of Special Counsel Jack Smith, the espionage report, the obstruction of justice report, the one that will outline what the American people need to know about who many of them voted for. Without dismissing that case, it will die this weekend. Monday will be Trump coming into office. He'll pardon those 2, and we'll never see the Mar-a-Lago report until 4, 5, or 6 years from now. That is the new request by Durbin, or demand by Dick Durbin, the senator on the Judiciary Committee, and Jamie Raskin. I'm going to read to you from that letter right now. It's a great strategy. Merrick Garland, wake up. Get your hair on fire, and let's get the Mar-a-Lago report out the door. It's the only way to do it. It's the only way to do an end run around and outfox, finally, Judge Cannon down in Florida. I'm Michael Popok. I'm hot on this hot take. You're on the MeidasTouch Network and on Legal AF. Let's talk about the strategy from a legal strategist perspective. The case against Donald Trump was dismissed in Mar-a-Lago despite the superseding indictment. Despite the allegations of major crimes committed by him against our national security, to hide classified documents, even nuclear secrets from the American people, from federal judges, from the FBI, from his own lawyers. We know that happened. That's why it's an Espionage Act violation as alleged. That's why it's an obstruction of justice violation. Now, when Donald Trump had the fortune to win election again, the Department of Justice dismissed the indictment against him. That indictment, that case, remember, had already been put on life support by Judge Cannon, whose patron is Donald Trump. When she dismissed the entirety of the case, sending it up to the 11th Circuit for appeal, finding for the first time in 249 years that an attorney general can't appoint a special counsel directly as an inferior officer under the Constitution, but has to go back through a Senate confirmation process, and funding the same way. That's wrong. That led the Department of Justice to try to fix that wrong, by taking an appeal to the 11th Circuit Court of Appeals in Atlanta to try to reverse that decision and get it off the books. But who cares about that decision at this point? It's an outlier. It's aberrational. No other court has adopted this. First of all, as my co-anchor Karen Freeman McNiffalo during Legal AF said last night, Donald Trump's not appointing special counsels. He's going to use his Department of Justice and Pam Bondi to go after people, along with Kash Patel at the FBI, if that happens. So don't worry about special counsels. And if he's going to appoint a special counsel, he's certainly not going to declare that it's invalid. So we don't have to worry about that precedent, right? This is like I used to have a client of mine who used this phrase, which I agree with here. It's like picking up pennies and nickels in front of a steamroller. Who cares about the precedent of this case that is really not precedential, right? Dismiss the case. And the 11th Circuit has already demonstrated in the last 2 weeks that they have no appetite to get involved in this case and reverse this decision. If anybody thinks, and I don't know what I'm going to do if I lose this bet, but if anybody, I'll wear a hat on my next hot take. If anybody thinks the 11th Circuit between now and Monday at 12 p.m. is going to rule on this issue, fully briefed in front of them for the last 5 months, given they've just issued orders recently saying, it's all moot now. Time has resolved our issue, so we don't have to rule. They're never going to rule on this. And the reason that blocks the Mar-a-Lago report from getting out, and the reason the dismissal that Jamie Raskin and Dick Durbin are calling for is so genius, but so important to America, is that Judge Cannon's holding a hearing today. And she's going to continue to block to the Congress. The statute for the special counsel, the law by Congress, says that at the end of a special counsel's his last gasp report, the final report, is got to go from Merrick Garland to the ranking members of the House and Senate Judiciary Committee. Has to. She's blocking that, arguing that since the case is still pending against D'Oliveira, whatever his name is, and Walt Nauta, right? The two henchmen, co-conspirators with Donald Trump. The case is still technically alive. She's got to protect she's got to protect the sanctity of that process. She's got to protect the criminal justice system for them. They have due process rights. Let's have a hearing. Let's let Donald Trump come back into a criminal case he was dismissed from and let him intervene in the case. Unheard of. Aberrational again. We're watching it though. We can't ignore it. We can't act like we're not seeing it. I can't unsee it. Merrick Garland's got to be seeing it. So we can't let her continue to have a hearing and continue to issue orders to block the release of the Mar-a-Lago report to Congress. Forget the public. And Merrick Garland's already said, I'm not releasing the report to the public until the case against De Oliveira and Nauta are over. Okay, end the cases. Because his little love note that he left for his successor on her desk in Pam Bondi, I think it's in the public interest to release the Mar-a-Lago report, is not enough. She's going to take that Mar-a-Lago report, she's going to throw it in the trash can. And it's going to be years from now, after a Democratic administration comes in, that we ever see that report. My daughter's going to be going to kindergarten or first grade by the time I get my hands on that report. Unless it's dismissed, the case is dismissed now. Let me read to you from the letter that was sent by the ranking member Jamie Raskin of the Judiciary Committee and Representative Dan Goldman of New York, who has an interesting background here. He's not only representing a major part of Manhattan and other parts of New York as a representative, but Dan Goldman was also in the Obama administration and was a manager in the impeachment process against Donald Trump as a lawyer. Okay, here we go. The American people now deserve the opportunity to read Volume 2 of Special Counsel Smith's report, which explains how President Trump knowingly retained hundreds of presidential and highly classified records at his Mar-a-Lago club and then deliberately defied subpoenas, obstructed law enforcement, hid evidence, and lied about his continuing retention of these records. It is in the very nature of American democracy, the letter from the ranking members continue, to know of the public actions of their public officials. And it is essential to the rule of law that Justice Department special counsel reports continue to be available and accessible to the public. As Attorney General, it is incumbent upon you, Merrick Garland, to take all necessary steps to ensure the report is released before the end of your tenure, including, if necessary, by simply dismissing the remaining criminal charges against the co-conspirators. We already got Volume 1. This is the only path to get the Mar-a-Lago report. I've said it before. I had a fevered debate with my co-founder on Legal AF, Ben Meiselas, about whether we'll ever see Mar-a-Lago. And unless they dismiss that case, we'll never see it. Because Cannon will either, if she continues to block it with the hearing later today, and I'll come back and report on that, whatever, it doesn't matter what she does. If she continues to block it, then that's just the Congress. We're just fighting over, again, picking up pennies in front of a steamroller. This is just about whether it can even go to Congress under her analysis, right? It's never going to go to the public, even after today's hearing, unless the case gets dismissed. Because if we wait until after the inauguration, Merrick Garland is out of a job, Pam Bondi is in, Carlos de Oliveira and Walt Nauta are pardoned, case is over, up to new Attorney General to release to the public, and she finds it's not in the public interest and countermands what her predecessor branded it as. She'll find it's not in the public interest to release it and goes in a desk drawer. We don't want that to happen. Merrick Garland, if you're listening, or anybody on your staff, dismiss the case. The precedent is not precedential. We don't care about it. No other judge or even the Supreme Court is going to side with her in the future. Don't die on this hill because it's killing American democracy. It's Michael Popok. I'm on Legal AF and on the MeidasTouch Network. I'm here on Wednesdays and Saturdays in a podcast, 5 years in the making, called Legal AF. I do work like this several times a day on the MeidasTouch Network. We formed a new channel called Legal AF, the YouTube channel. We need help continuing to build that, because that's going to be a hot corner, that intersection of law and politics, in another 5 or 6 days, I assure you. And then I got a brand new show called Popok Live live on Tuesdays at 8 p.m. right here on the MeidasTouch Network. We got a growing audience, several 100,000 a week watch Popok live, and I appreciate you being there. It's a humbling experience when we launch a new podcast or a new show, and we get such a turnout. So really do, from the bottom of my heart. So until my next reporting, I'm Michael Popok. In collaboration with the MeidasTouch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories, the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.